Hi, I'm Shan Wu with a undercolor of law analysis of what I'm calling the Abrego Garcia loophole. Now, I posted on Blue Sky that when the Supreme Court made its shadow docket order about what the administration should do about its mistake in disappearing Mr. Garcia, they left a loophole large enough to fly a plane through it. And that's particularly because they, rather than ordering the DOJ to bring him back, they use this word facilitate. And we are now seeing exactly how that loophole is being exploited by the Trump administration. So let's start with pointing out what it is that the court had said. So they said that the order, meaning the district court order, properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as if it would have been had he not been improperly sent to El Salvador. The intended scope of the term effectuate, that's what the district court originally said, the Supreme Court says, is however unclear and may exceed the district court's authority. The district court should clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. For its part, the government should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. So in this language that the Supreme Court used, one can imagine maybe Chief Justice Roberts wanted to make a strategic decision to step into this case and tell DOJ to do the right thing and yet not sound like he was somehow undermining the ridiculous authority he had conferred upon Trump in the presidential immunity decision, where Roberts demonstrated his obsession with useless recitations of law at precisely the wrong time. Let me explain. The central point of his opinion back in the presidential immunity decision is this useless, what I call it's just a construct. I mean, he constructed it with this core set of executive powers that included the commander-in-chief powers, and that ran head-on into the Court of Appeals judge hypothetical, about political assassinations. If you're ordering the military to assassinate people, isn't that going to this core idea that Roberts wanted to point out, that the president's the commander-in-chief? It's not like nobody understood he was the commander-in-chief, but Roberts had to lean into that. Well, many scholars have noted that dictators nowadays don't have to unleash the military right in the streets on the citizens. They have other methods to use. And this case, the Garcia one's a perfect illustration. Roberts has given Trump the cover to hide the disappearance of a U.S. citizen or naturalized citizen, green card holders, and potentially even U.S. citizens, we'll talk about that later, behind the cover of conducting foreign policy. And that's perfectly reflected in the DOJ response, which was filed on Sunday. I'll put that up for you. So DOJ writes, defendants understand facilitate, quote unquote, to mean what that term has long meant in the immigration context, namely actions allowing an alien to enter the United States. Taking all available steps to facilitate the return of Abrego Garcia is thus best read as taking all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return here. Indeed, no other reading of facilitate is tenable or constitutional here. So there you have the reliance upon the word facilitate. They build on that. We'll put up next excerpt here. Government writes, on the flip side, reading, quote, facilitate, unquote, as requiring something more than domestic measures would not only flout the Supreme Court's order, but also violate the separation of powers. The federal courts have no authority to direct the executive branch to conduct foreign relations in a particular way or engage with a foreign sovereign in a given matter. That is the exclusive power of the president as the sole organ of the federal government in the field of international relations. And it's beyond the scope of the federal court's equitable authority. So there you have it, the reliance on the president's foreign relations. Trump regime wants to say this is part of being commander-in-chief, running our foreign relations with other governments. And then what they really do is they drop the mic on what they've been really working to do, working to lay the foundation for. So let's take a look at kind of the piece de resistance for their logic. They write, plaintiffs' additional relief runs headlong through this constitutional limit. They ask this court to order defendants to, one, make demands of the El Salvadoran government to dispatch personnel onto the soil of an independent sovereign nation and send an aircraft into airspace of a sovereign foreign nation to extract a citizen of that nation from its custody. All those requested orders involve interactions with a foreign sovereign and potential violations of that sovereignty. But as explained, a federal court cannot compel the executive branch to engage in any mandated act of diplomacy or incursion upon the sovereignty of another nation. Plaintiffs invite this court to exceed its own authority in the precise sort of way the Supreme Court cautioned against. So there you have it, exactly how they're using that loophole that Roberts gave them to basically tell the courts to go pound sand about bringing Garcia back. Now, this dovetails perfectly, of course, with Trump's own social media post bragging about how Garcia is now in the, quote, sole custody of El Salvador, a proud and sovereign nation, unquote. I'll spare you putting up his post. And also bragging about how he, Trump, is working with El Salvador to combat terrorism. Again, putting this into his national security commander-in-chief bucket of what? I'm not entirely sure of, but definitely a bucket. And what this really sets the stage for is even further outsourcing of U.S. prisoners. Now, we already have reporting that they're talking about doing that, and they make it plain that their plan is to keep hurriedly shipping off people under the guise of deportation to foreign countries. Once they get there, then they can claim, oops, we have no authority to do anything about it. We, being the courts, can't do anything about it, and we don't want to do anything about it because we, DOJ, wants to claim these are all a bunch of terrorists, criminals, even though we haven't had to make any kind of showing. There's been no process for that whatsoever. Just to pull back for a moment to a even higher level look at this, you have to wonder, since they originally said, oh, this was a mistake, we didn't mean to ship this person out, that's a mistake. Now, why don't they want to correct that mistake? Right? It's not the best example to use if you made a mistake. Well, certainly there's a great deal of racism behind the mistake, why they could care less about this person. But number two, it's not this particular person that they care about. They want to make it a point, we can do this process, send people outside the country, and then there is nothing that the courts or any lawsuits can do about that. That's where they really want to go with this. And because of what Roberts has done, looks like they have a pretty good chance of success at doing it. So we're going to have to see how the district court judge handles this interpretation and what the court says to them. And we'll keep an eye on that and report back to you. Thanks again for the replies and comments, and we'll be talking to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.